colleagues, we've come here in solidarity with our colleagues in the media who are being intimidated by Office of the Director of Public Prosecutions in collaboration with the judiciary, because today we've heard for ourselves and we've seen what is going in court, and we've seen the magistrate who is hearing this matter behaving as if this is a personal matter when the prosecution actually brought the complaints before her. And therefore we say this is an assault on freedom of the media, and we are ready to fight and protect freedom of the media to the bitter end.
Let me add something. I think it's important for us to understand that insofar as judges and magistrates have a public duty to administer justice, the media also has a duty to inform. So that in this case we are dealing with contending public interests. The interest to administer justice that is bestowed upon the judiciary, and also the interest of dissemination of information that belongs to the press. We would expect our judiciary to be very slow in crossing over to start harassing the press and intimidating them in trying to tell them how to report. That is crossing the boundaries in a lot of ways, and it's unacceptable.
Let me just add something before the council speaks. The law actually stipulates that you can actually seek redress if you feel that the media has misreported something or has violated the code of conduct for practice of journalism. And I'm sure the judge and the Office of Director of Public Prosecution, they know that in the event they feel that maybe the media, there was an overreach on the side of the media, we have the Media Complaints Commission, where they could have filed such complaints and action taken against the journalists who violated the code of conduct for practice of journalists.
What happened in this matter? That a story was aired on media. The matter started in March in the famous NYS case. Witness was put to cross-examination. After cross-examination, the media covered the story. 6 media houses and hundreds of bloggers covered the story. Only 2 media houses were selectively picked. The trial for their contempt proceeded without them participating. Summons were issued. The summons, when they were issued, the 2 co-editor appeared, and the 2 co-editor was never served with the official complaint, the charge sheet, on the allegations of what he transgressed. He was sentenced to pay 50,000 shillings, serve 6 months. That sentence, we respect it, but it is so punitive. Yet he was again ordered that he must go and do an apology. An apology is a management question of media houses. It has never been about editors or about reporters or correspondences. An attempt to explain the structure of how media houses operate was not listened, and that editor was sentenced to serve 5 days without an option for fine. An editor doing his job has slept at prison. Today, the learned judge has vacated those orders and ordered that editor to be released. Coming to the KBC matter, the similar allegation Today, our client was supposed to appear before the court. A tape, the alleged tape, was supposed to be played. We refused and said we must be given the proceedings of that day. The specific proceedings of the 25th of March 2022, which now the court has agreed that it is prerequisite for the rules of natural justice for our client to have them so that she can mount a serious defense. We will be before the same court tomorrow. Issues that are coming out is that we feel very strongly, and I raised it before the court, that the charge sheet, the offenses, the complainant is the Director of Public Prosecution. And the Director of Public Prosecution has narrowed to the day the alleged offense was committed to be the 25th of March. But the court is expanding the whole proceedings. We have objected to that the court's role is to arbitrate. Based on the conduct of the court, I have received instructions to file to the JSC a complaint for the removal of the magistrate. Based on that, the Kenya Union of Journalists has written to the Chief Justice attention that the cordial relationship between the media, the fourth estate, and the judiciary is being destroyed. We are seeing from the conduct of this matter, the days of Bernard Chunga, when people could be prosecuted and be convicted without them being heard. We are seeing a very assertive judiciary jailing editors. What is the cordial relationship between the Director of Public Prosecution, the judiciary, and the fourth estate? We are equally moving to the High Court in the next few hours to challenge the decision of none following the procedure of complaints against the media. The Media Act specifies procedures whenever any Kenyan is aggrieved, or anybody is aggrieved on the questions of alleged misconduct of the media. Criminal sanctions are not part and parcel of that process. So we shall be calling upon the Chief Justice to rein in on her officers to ensure that the media practice their profession without any interference, without any threat, without them fearing that they'll be committed to jail. Those are the instructions that we have, and as I've said, in a few minutes' time, we will be executing those instructions that we have received from the Kenya Union of Journalists, from the KBC, and from all the media houses, that this is an issue that even can lead for the media to black out judiciary. How will Wanjiku know what is going in the court system? That's all, unless there are any questions to that effect. Any other?